Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, FRAND licensing, patent pooling, and patent litigation. So let's dive into today's episode. Let me welcome to our SEP Couch today. Our next guest, Jon Putnam. I'm very excited to have you here, Jon. Jon is the principal and founder of Competition Dynamics. And Jon, you have, in a way, a CV that is not too far from mine. I also started in the world of academics and then started my own company. So did you. And actually, when I just started working on SEPs, some of your articles I actually cited and read through it for my PhD. So I am aware of your work since over 10 years, to say that way, following it. And of course, we work with Competition Dynamics a lot now with your company. So I think it's a great cooperation and it's great to have you here. Welcome.
Well, thank you very much. It's a delight to be here. And if you survived reading about my dissertation, then that makes you better than most. So thanks very much.
I did. And I cited you a couple of times and I found especially the valuation papers quite exciting and it fit well to my topic. So I think that makes sense that we also even today work together. That is great. But I mean, that brings me to my first question. Everyone who is on my virtual SEP couch here, I keep asking in the very beginning, how did you come to the topic of SEPs? Can you elaborate a little bit on your career? What were the different steps? What was important to you to start?
Sure. So I actually started out as an undergraduate interested in R&D and productivity. And so I wrote my senior thesis on agricultural productivity and then got hired by a couple of members of the Yale faculty to work on measuring the output of agricultural experiment stations in the United States. And one of the output measures was patents. And so I learned about counting patents and all the problems with counting patents. And this was in the early 80s when people were just beginning to think about, is there a better way of valuing R&D and intellectual property rights than simply counting things? And so I eventually wrote my dissertation on the international patent system and using information contained in patent family filings to measure the value of international patent rights. And so the end result of that was being able to measure all the value of all the patents in the world, which was a short 13 years later, I finally finished. And then, so for SEPs, I began working on valuing patents, for patent damages cases. And then I got asked to do something for InterDigital. And they came to me and said, we have a problem and we think that you've got a good background for it because I've got a background in international trade and competition as well as IP. And they started using all these acronyms like CDMA and WCDMA and CDMA 2000. And I kept going like, can they please think of another acronym besides CDMA? And then they say, oh, we have another one. It's called TDMA. I'm like, how about something that, I couldn't keep track of all this. And then there was 2G and then they were talking about 3G. And so I was like I knew nothing about this. But then gradually under the tutelage of a very good lawyer named Mike Levin at Wilson Sonsini, I learned about ETC and standard setting and the problems that companies like InterDigital face and also the licensees face. And so that was probably 20 years ago or so. And since then, I've probably done 2 or 3 dozen cases involving standards of various kinds. So it's, and now it's become something where it's branched out a lot from cellular, so that learning how to value other standards has become thinking of other creative ways when you don't have the same standard development organization has been a big challenge and also quite interesting. And you've helped a lot with that, I should say, with your database.
That's great to hear, Jon. Maybe for people who do not know what Competition Dynamics is, the company that you founded, could you elaborate a little bit of what you do? I read you are an economic advisory firm, but what are the typical cases where people work with you, and what is your specialty of what you do in your advisory?
Well, so I founded the firm because I worked previously for a large standard consulting firm, and I did part of their intellectual property practice. I wanted to do something that was more research oriented. And so I felt like anybody can be a consultant, But the world doesn't need another consulting firm. It needs to have its problems solved. And so I wanted to create something where we were going to focus explicitly from the very beginning on dynamic investment. Usually consulting firms treat intellectual property as being kind of a species of their antitrust practice or something like that, or they have a bunch of accountants or something. And I wanted to start out from the beginning and say, we're not doing straightforward antitrust. We're doing dynamic investment problems, and because that's really what intellectual property is, and in particular, that's what standard essential patents are: is a systemic effort to invest dynamically to create technology that's useful to everyone and disseminate it in a fashion that is sustainable and fair. So that's why it's called competition dynamics, is because we do competitive analysis of dynamic investment, and we work on exclusively on intellectual property, but then also the antitrust and competition aspects of that, and also the international trade aspects of it. So those are really our three specialties: IP, antitrust, and trade. And that's again where SEPs are especially interesting, because they really bring together all three of those dimensions, and that's really our sweet spot.
Very interesting. And in that regard, I'm sure you often get the question, what is actually a FRAND rate for an essential technology? And maybe for those people who do not directly understand what that is or want to know more about it, what is your typical answer?
Right. So FRAND is obviously fair, reasonable, and non-discriminatory, and that's a standard setting organization typically requires that people whose patents are used in the standard agree to license on those terms. And so that's kind of a simplified way of talking about that is to say, well, what is a firm's FRAND rate? And that by itself gets you off on the wrong foot, because a rate is only one dimension of a contract. And so trying to summarize a contract with one term is mathematically impossible. And in fact, many FRAND agreements and most of the large FRAND agreements don't have rates at all. So the answer to the question, what's a FRAND rate, is there is no such thing. You've committed to licensing on FRAND terms and conditions, and then you have to analyze those FRAND terms and conditions to see whether, as a set of terms, they conform to the obligation that the licensor has assumed in offering its patents for use in the standard. So we try to disabuse people at various points in the process of the idea, and particularly I would say judges, that there is such a thing as a FRAND rate, or that the goal should be to set a FRAND rate, because that's really an oversimplification of the problem.
Very interesting. And another thing that, is something that is very often debated, and that's also why sometimes it leads to litigation, is that a licensor and a licensee, there's some licensor that has an offer, and the licensee, can agree or not agree or wait on, reacting to that offer. And, I think many people are not aware that, the standards are implemented years before the licensing even comes in place. And there's years of negotiations before typically a litigation, or it comes to a litigation. So I think you said at some point, you said something, the cost of delay. Could you elaborate on that a bit?
Yes. So we have done a lot of work on trying to figure out, how the system is supposed to work. It's actually the SEP system is actually quite backwards, and that's a larger topic we can get into if you want. But it's backwards in the sense that it's not really what economists would call an optimizing process. And so one of the aspects of this that has been asserted by some people is that because the licensor is committed to only charging a FRAND rate or FRAND terms and conditions, then the most that the licensor can ever get for a royalty is the opening offer. And so that leads to sort of perverse incentives, because if the offer can never be worse than the opening offer, then a licensee can always guarantee itself that outcome by simply accepting the opening offer. So in other words, there's no cost to delay, and this is what leads to holdout, which is opportunistically taking advantage of the licensor's investment in R&D, and then either refusing to negotiate or engaging in sham negotiations and this sort of thing. So what we've done is actually work on figuring out the systemic cost to the system, and in particular to a licensor, of holdout behavior by a licensee, and then being able to measure that, come up with a rate card or a schedule that says, if you sign the contract today, then here's the terms and conditions that we're offering. If you delay, the terms and conditions get worse, and they get worse not because you're charging more for your technology, because you've committed to charge a fair rate for your technology, and you can't just keep increasing the technology rate. But what you haven't done is agree to bear all the costs unilaterally of the delay imposed on you and on your licensees by this prospective licensee. So we've taken into account all the market distortions, all the advantages that a licensee gets by not entering into a contract, and simply saying those are also compensable under the patent laws of most countries, because the idea is to leave the licensor as well off as if the license had been negotiated originally. So long story short, the terms do get worse over time, and holdout behavior is not rewarded. It becomes taxed or penalized. And that's been a difficult process. We've been working on it for about 3 years, but it's actually quite interesting. And I think it satisfies people's intuition that you shouldn't be able to just get the opening terms after 3 or 5 years of delay. There should be costs of engaging in that. Or in other words, if you engage in bad faith, it goes badly for you. And the question is, how can you measure that? That's what we've done.
Right. No, very interesting. And I think also, thinking as an economist, it's all about incentives, right? And if you set the incentives right, actors act by that, right? I think that is a principle that I find also very logical, thinking about these complex issues. That leads me to my next question. You are an expert in valuation, not only SEPs, but also patents. How would you compare the two? I mean, of course, an SEP is a patent too, but it is a special patent, let's say. What's the difference when evaluating patents to SEPs?
Well, I think that I've asked myself this question now for many years, because it's such a complicated and unusual set of facts. Think of it this way. Imagine that you were going to a shopping mall, and you had to buy everything for your house. But instead of going there with a budget and saying, well, I have $20,000 to spend on furnishing my house, they said, well, you have no budget, and in fact, there's no prices on any of the items, and you can pick whatever you want, and you can pick the best thing. In fact, you should pick the best thing. Pick the best thing for your house, and there's no prices. And so, of course, what you would do is you would go to all the most expensive shops and with all the best brands, and you would pick the highest end thing, and you would assemble the most elegant apartment you could possibly find. And then people would come to you afterwards and negotiate with you for how much you should pay for your couch and for your stove and all this sort of thing. And so you wouldn't have engaged in what economists call an optimizing process, because you wouldn't have selected these things based on their prices. You would have selected them purely based on their features. And so and then imagine that if you picked a Bosch or something, or Brown stove, then you would pay for that stove, but then all the other stove manufacturers would go out of business because they had no one else to sell a stove to. Then from their perspective, the question is, what would that manufacturer charge you once they had been selected by you? What should they charge you? Should they charge you the market price for a stove, or should they charge you a special price because they were the ones that were selected? They won the lottery from their perspective. So you have a very unusual process that doesn't bear any resemblance to actually shopping the way people do in the real world, or bidding for things and taking into account prices. And so because of that, you get standards that consist of the best of everything, that are chosen without prices, and then people have to come along afterwards and make up the prices. And trying to figure out what the prices ought to be is extremely difficult under those circumstances. both because the buyer didn't take them into account when selecting the invention into the standard, and the seller is a winner take all among several competing sellers. And usually in a winner take all environment, the winner gets everything and the losers get nothing. So for this reason, you can't rely on traditional kind of antitrust market-based competition analysis, because that's not what created the standard in the first place. And that's, I think, probably what makes it especially difficult and especially different from valuing, an individual invention that is being sold in competition with other individual inventions.
Yeah, very, very interesting comparison. And thanks for the German brands example. I guess we do make the best stoves. I don't know. But
of course.
Going one step further, one study you did, which is super interesting, but I know you cannot disclose the specifics of it, but at least I read the summary of it. It's called The Disagreement Among Technical Experts with Regard to Patent Essentiality. And you looked at the, you looked basically at data where subject matter experts did map patents, that have been declared before. One, for example, was also the Conquer IP study in the TCL Ericsson case, which is, I think, many people are aware of. And compared that with other studies, for example, from PA Consultant Group, what was the finding here, and what did you do in this study? How did you compare the essentiality rates, and what was your conclusion in the end?
Well, so I often tell people, I actually think technology is really interesting, and I'm often being deposed or interacting with lawyers who have a technical background, and I, basically, as my wife will attest, can't fix a toaster. So I don't know anything about technology, and I don't pretend to know anything about technology, but I'm interested in people who do know about technology. So one of the key questions, as you obviously know from IP Lytics, is which of the patents that are disclosed to a standard are actually essential, and that matters when you're working for an individual litigant, because they want to know how many of their patents are essential, because they want to know whether they've made a FRAND offer for their portfolio, for example. The problem with that is the question is, which study do you rely on? And how do you rely on a study without being accused of cherry picking? Is Concord IP a reliable study? How would you know? So one of the things that we did as an economist was to say, we don't know anything about technology, but what we do know is statistics. So let's go look at all the studies we can find and see, do they agree with each other? Or how would you know? In other words, what's sort of the consensus of people's opinions about Qualcomm's portfolio or Nokia's portfolio or whatever? And so it turns out that we did some relatively simple data analysis, and we found that when you compare these various studies, both for 3G and for 4G, they disagree with respect to individual licensor portfolios, their essentiality rate. They disagree in a statistically significant way more than half the time. So this doesn't indicate that there is really a consensus, that even technical experts who supposedly don't have a dog in the fight come to different determinations about how the rate of essentiality for any individual licensor's portfolio. So then, given that finding, that there doesn't seem to be any consensus or single study that is the most reliable, we then developed a model that said, well, let's take all of these studies, put them together in a big black box, and figure out the predicted essentiality rate. Because if somebody makes an offer that is consistent with the average of expert opinion, then it would be hard to say that that wasn't a reasonable offer. People are going to disagree about this, obviously, but a judge can't look at you and say, well, you were unreasonable because your offer is, consistent with everybody. That would be a hard conclusion to draw. So we wanted to, without taking a position on individual studies, come up with something that judges would find reliable and that they wouldn't feel was cherry picked. So that was the basis of our study, was observing individual disagreement and then trying to combine studies into a single kind of meta study that gave you a consensus estimate of essentiality rates for each licensor.
Interesting. Can you talk about how many of those studies you used, or how many are needed to get like a baseline stack of data that that you can rely upon, or are two studies even enough? Or
well, we what we did was for the our study has two parts. One of them was to compare pairs of studies. So, for example, look at Concord versus PA Consulting, since you mentioned those two, and then look at an individual licensor like Ericsson and say, do Concord and PA Consulting agree about the Ericsson LTE portfolio or not? And by agree, what I mean is their essentiality rate sufficiently close that you would say that statistically they're not different? And then we do that with various pairs of studies. So we took all the studies that we could find, I don't know, 7 or 9 or something like that, and then compared them pairwise for each individual licensor. And so the only restriction there is if a licensor is so small that they've only got 8 patents in their portfolio, you can't make the comparison because there's too few data points. But for the large licensors, you can do this. So if you treat a data point as being like a study and a generation and a licensor, so PA Consulting, Ericsson, 4G, that's one observation.
Right.
Then we have, I give or take, maybe 150 observations, something like that, of the largest licensors. And then you can use that to create this meta study that models the essentiality rate for everybody, and then a general industry essentiality rate for the smaller players.
Yeah, no, that makes a lot of sense. And I think that is something very exciting what you guys do, what many technical experts, on the other hand, sometimes, don't understand in full because they keep on looking at the individual patents and somehow, keep claiming they are biased. And these people only look 10 minutes at the patents, others look 10 hours at the patents.
Yes.
But then in the end, as to the rule of large numbers, that matters for individual patents, maybe, but on the portfolio level, on comparing, a certain number of studies, it doesn't matter. And I think that is a level of understanding that, for you as an economist, myself included, as an economist, makes a lot of sense. But I think we need a lot of education for technical experts who maybe in return, I'm the same as you, I don't know anything about technology, can teach us how to claim chart maybe, or what's important. But I think that is often ignored, that at some point, it doesn't matter if it's 10 minutes per patent or 10 hours, right?
Yes, and I think that's, particularly when you're talking to judges who are very fact-oriented. They're used to thinking in terms of individual fact patterns. Where was the knife in relation to the victim's neck? This sort of thing. And they want to know about that patent and those facts underlying that. And so when an economist comes along and says, "Yeah, I don't care about any of that. I just care about whether there's 10,000 of them. I want to know about 10,000 knives because I'm studying 10,000 murders." This seems inherently suspicious, and it's hard to sometimes to get a meeting of the minds with people who are not trained in large numbers. That's true.
And I'm curious, did that change over the past years in terms of judges and the overall recognition of economic studies, regressions? I mean, these are very also technical things in terms of statistically technical things. Is this more accepted these days, would you say, or is it something that...
Tim, I will tell you the truth. I don't know. I hear very good things about the judges in Germany. So yeah. I know nothing about German judges, and I mean no disrespect. So I'm primarily familiar with American judges, and I would say that American judges are going backwards. And what I mean by that is that unlike a technical field like chemistry or electrical engineering or something like that, where a judge would defer to the economic expert, to the technical expert, I would say we've seen an increasing willingness on judges' parts to roll up their sleeves and come up with their own economic model, which I find maddening, and disheartening and flabbergasting, because judges aren't trained in this fashion. And there's a level of sort of contempt for the process of crafting a remedy, where a judge is supposed to craft a remedy, but sometimes that extends to calculations that simply don't make any sense. So in the last 8 or 10 years, we've seen various judges, and I will say this, TCL being one of them, where the judge has come up with an entire formula for how to compute the value of an SEP. And I just feel like it's sort of like if I, as an economist, I know a little bit of law, and I can probably draft a contract, but nobody should ever trust me to draft a contract. That's why you go to law school. And so the idea that I can come with words that look like a promise is, I mean, that's great, but it's amateur hour for me. And it's sort of the same thing with a judge trying to come up with an economic model. It's like, well, that's a very nice try, and you did a great job. Now start with, 8 years of economics training, and then do it again after you've done that. But the idea that you can just pick this up is false. So I find the education of judges in particular to be a long-term project that hopefully I won't lose heart at.
Interesting to hear that. And I can, quote on German judges. I think Germany is known for good judges in terms of technology knowledge, but I wouldn't be sure about economic knowledge. And the whole law and economics as a topic is also something that is not so popular in Germany or in Europe as a whole, which I think is very exciting. And but my feeling is it's also not yet as accepted or used or known in the markets. But we're getting there. We're all pushing for that.
Yes.
Jon, there's another very interesting study you did. I heard that you really got hands-on non-disclosed bilateral contracts of licensors and licensees. So you had an overview of who actually paid how much for patents, right? For 3G and 4G and things that are unfortunately not public. And you studied that. Could you also elaborate on that, at least as how much you can talk about it? I know most of that is under NDA, but I found that very fascinating that you guys had access to that database, at least at some point.
Yes. Well, so this was I would say that of all the cases I've worked on, probably in my career, this was the most interesting one because this was the Federal Trade Commission versus Qualcomm and the Apple versus Qualcomm case. And because there was so much at stake in those cases, this was really sort of an existential threat to Qualcomm in some ways, because it really challenged their entire business model. The parties subpoenaed every license in the industry, basically since the year 2000. So if there was a material SEP license, so there were hundreds of licenses that were produced, many by third parties. So typically in litigation, you only have the licenses of the two parties, and that may be an interesting cross-section, but here we have everybody's. And so the Federal Trade Commission and Apple didn't really know how to make use of this data because there isn't really a good model for analyzing these extremely idiosyncratic, long, complex documents that have highly unusual terms. But this was a case where Qualcomm's business model was at stake, and they needed to answer an important question, which is, are the terms that Qualcomm offers reasonable in light of what everybody else in the industry does, or does Qualcomm charge an excessive price? And how would you know? So we developed a model that allowed us to analyze every license in the industry, whether it was a lump sum agreement or a running royalty, whether it was a one-way license or a cross license, whether there was a release payment or not. We matched every license with the handsets and tablets that were licensed under that agreement over the term of the agreement. It took millions of dollars of resources and a team of lawyers reading the agreements to actually, reduce all these things to a data set. It was absolutely fascinating. And but at the end of the day, it told you many things that people think are true about licenses, but don't really know. For example, is there a volume discount associated with sales? Do you pay less on a per handset basis if you're licensing 100 million handsets than if you're only licensing 50 million? Well, the answer is yes. Do you pay less on a per patent basis if you're licensing a large portfolio versus a small portfolio? The answer is yes. Do you pay less for sales that you made in the past than you do going forward because you compromise on released sales? The answer is yes. So we could investigate all of these hypotheses with a large sample of licenses Do you pay more? Here's a good one. Do you pay more for a 3G patent than for a 2G patent on average, holding all else constant? The answer is no, which is kind of reassuring because people are, there's nothing intrinsically valuable about 3G more than 2G. It's just more complex. And the same thing with 4G than 3G. It's more complex, but on a per patent basis, it costs about the same amount of R&D to produce that. And so you wouldn't expect it to be fantastically different in value. And it turns out it isn't. So we discovered a huge number of really interesting things about the data. The difficulty is it's hard to know how to publish this without running afoul of confidentiality restrictions. So I'm still sort of working on that. But I found the experience of all the interesting issues I've ever worked on, empirical issues, this is probably the single most interesting because it answered so many questions that people actually want to know the answer to.
Yes, no, I think that is really fascinating because everyone calls for transparency, especially in that comparable license, argument of how to value a SEP portfolio. And it's always the argument that comes up is that, yeah, you can find any contract that you think is comparable, but I find another one that is different, right? And then you have two data points again, and then you actually start all over again. But if you have everything, right? I mean, then it's very interesting, and especially I like. Because these, as you said, these license agreements, these FRAND rates are not really rates. These are complex contracts that take into account a lot of things, very complex agreements, and getting that to one comparable variable, very exciting work. I'll follow up. I would love to see that published even more. I would love to have it in the IPlytics database, to be honest. People keep asking about that too. But yeah, I know, probably not realistic. But that brings me to my next question. I think transparency is a topic in general in the industry that many people call for. Especially in Europe, we have the European Commission pushing very hard into encouraging more transparency because, I think Europe is kind of scared that, the industry that we have, the automotive, but also the manufacturers, that with IoT and, 5G being implemented everywhere in the Internet of Things, those companies are not well prepared because they have no experience with licensing. There's nothing public. Something like your study would help them in understanding. This is what we have to deal with. This is the starting point, and this is a good offer, and that's maybe a difficult offer. What is your opinion in general on transparency? If everything would be transparent, is that even beneficial, or what level of transparency would you as an economist think makes sense?
Well, I think that there's so that's a really good question. I think it's a multi-layered question because there's different types of transparency. So there's transparency of prices, meaning that you have to enter into you have to disclose the terms of the license that you enter into. That's one level of transparency. Another is transparency about the claims and sort of, is a patent essential or not? Or is it, how would you know, like you said, publishing claim charts and that sort of thing. I greatly favor the efforts to determine better, independent efforts to determine better whether patents are essential to a standard. Whether it's publishing claim charts or whether the organization, the standard development organization actually makes its own determination, that sort of thing. It's very inefficient to try to be arguing about this bilaterally because we've already talked about how different technical experts come to different determinations, different negotiators come to different determinations. It's the same argument being applied to the same patent over and over again. It's overwhelming for any actually individual licensor or licensee to try to figure out all the patents in that are disclosed to a standard and whether all of them are essential or not. It's hard enough to do it for a particular portfolio. So I think that, basically, anytime you can make an investment in information that everyone can use, that's an efficiency improvement. I do think there's going to have to be some decentralized bargaining. And if there's going to be decentralized bargaining, it may have to be kept confidential in some fashion because people have very different interests and preferences. And once you commit to disclosing your license terms, then you make it difficult sometimes you make it difficult for other parties, more difficult for other parties to reach an agreement. And one of the reasons is because there isn't an agreed upon formula for comparing licenses. So I've been in many litigations where a very small licensee will say, well, I deserve the same rate as Samsung, let's just say, the largest licensee, on non-discriminatory principles. And then you point out, well, Samsung, let's just say, or somebody doesn't have a rate in their license, and they paid a lump sum. And then they say, well, I want the same effective rate. Well, that's not the same thing. That's not a rate. And so I think that your point is that transparency would be a very good thing insofar as it increased the trust between licensors and licensees, because I feel like there's very little trust. It's become like a religious divide in some ways. Increased the trust between the parties, and insofar as there was an agreed upon way of interpreting the information that was made public by the transparency. And right now we don't have very much trust, and we don't have agreed upon mechanisms for interpreting data. So if you publish data that people are simply going to use opportunistically to beat up other people with, then all you've done is you haven't made the world a better place. You've simply given people more free weapons to fight with. And so you've increased the intensity of the war rather than decreasing it. And that would be a mistake. So I think you need to make some institutional and methodological advances. For example, by making bargaining between licensors and licensees more symmetric. If both parties have an affirmative duty to negotiate in good faith, for example, then that helps increase the symmetry of the bargaining, and then you can make progress with transparency, I think.
Something like a playbook of how to determine FRAND, of different approaches.
Yes, I think that exactly. And also I think when both sides have to come to an agreement of, right now the licensor undertakes to license on FRAND terms. If the licensee in order to implement the standard, if the licensee had to commit to pay on FRAND terms, so that there was a symmetric commitment on both sides' parts, I think that the market would go some distance towards solving this problem, because there wouldn't be this incentive to hold out or wait for the licensor to come up with something that was acceptable, and then for the licensee to simply say, that's not good enough, or I want better terms, or you're discriminating against me, or something like that. And I'm picking on licensees because I see relatively, I think of as being simple-minded objections, but the whole system is actually way too decentralized, and one step towards the right degree of coordination would be the kind of transparency you're talking about.
Yeah, no, that is interesting. And I think it also ties up to my last question of today, which is going a bit towards trends and, and disputes, and, you've been in all these different litigation. Do you see any trends? You said earlier in this interview, judges sometimes go backwards. What we see, as you said, there's a lack of trust. Maybe also a lack of trust in different systems, as you said, in judges, in courts. There's forum shopping. Certain courts, at least assume you to have, certain outcomes. Different jurisdictions, it all becomes more complex. Is there any overall trend you see that you would think, this is where we came from, and now with 5G coming up, I see this has been changing, or is it in the end all very similar, what's going on right now?
Well, I have to say that I think that the world may get worse before it gets better. And what I mean by that is that we now see this has risen to the level of international trade strategy. So you have individual countries asserting global jurisdiction for the ability to set FRAND rates. The US hasn't done that, but the UK has, and China has. And now you have anti-suit injunctions and anti-anti and this sort of thing. This is an arms race that no one can win. So you're going to have some kind of international coordination and that tries to take advantage of the benefits of decentralization and the benefits of the market and the benefits of bilateral negotiation, but that also doesn't cede to any one country the ability to determine prices in the interest of its own combination of innovators and manufacturers. The US, for example, is now not a manufacturing company. It's primarily an innovation country, and it's going to have very different interests than, say, China or some of the other East Asian countries where manufacturing is really important. And I guess I would say that the trend I see is towards international disharmony and without a clear solution in sight. And that makes me, that's obviously good for people who make money from disputes, but it's not good for global efficiency or 6G and 7G and other standards.
Yeah, no, that is interesting, especially, of course, when we think about trade wars, and that standards have become part of that, right? I mean, with the ban of certain products, and just hope that the 6G and 7G will still be an international standard and not, just a few countries that will adapt it. I think that's something that would not make sense. And that's a situation that I think with 2G we already had. And, where are we right now? Traveling these days is so, you don't even see where you are. You have connection everywhere. And I think that's something people these days just think it's normal, but it's actually a lot of technology and agreement behind that, and everyone agreeing on the same standard worldwide. It's actually pretty fascinating if you think about it.
Yes,
we shouldn't lose that. That's very valuable, I think, and I fully agree. Very good, Jon. Maybe the last part of this, what I always do in the very last question, you have something like an elevator pitch, which is basically about what do you hope the audience will leave today remembering from you?
Well, as an economist, I guess I would say it goes back to why I started my company. The world doesn't need another consulting firm. The world needs to have its problems solved. And we try to solve problems in a way, particularly when it comes to SEPs, in a way that represents a solution not simply for a client, but for a system. So we've developed methods to value essential technology that we believe can be implemented by anybody, whether they are a licensor or a licensee, as we did in the Qualcomm case. If you find terms that work for everybody, then you actually can reduce disputes. And it would make me happy globally if my firm got less business because there was greater harmony and greater agreement on the truth. So what we try to, until that day, we try to develop methods that are reliable for licensors, judges, and licensees. I would love to work with anybody who feels similarly.
Great, Jon. Thank you so much. That was Jon Putnam, founder and principal at Competition Dynamic. Thank you so much for your time, Jon. Very exciting interview. Lots of very good topics. I think we could talk for hours here, but this is really exciting. And I'm very sure your company will not go out of business. There's a lot of problems to be solved, in particular about what you do, and you do it great. So thanks for this. And we'll catch up soon, Jon. You have a good one. Bye.
Very best of luck. Take care. Thanks, Tim.
Bye.
See you. Bye-bye.